Hi everyone, this is Pennsylvania attorney Evan Gutman with video number 23 of my legal video education series based upon my book State Bar Admissions and the Bootlegger's Son. The book, along with two other books, is available on my two websites, one of which is gutmanvaluations.com and the other of which is heavensadmissions.com. The other two books, one is a supplement to State Bar Admissions and the Bootlegger's Son that I wrote several years later, as well as a fictional novel called Heaven's Admissions Process, which compares the process to be admitted into heaven with the process to become a licensed attorney on earth. It's a fictional novel, comical, upbeat. I think you'll find it enjoyable. All three books really focus in large part upon the good moral character requirement to obtain a law license and the manner in which it is applied in a quite poor way, in my view, by the judiciary. And also the books address other topics which may fairly be stated as somewhat heated issues in the legal profession, but I think you'll find them interesting. So in today's video, I'm going to explore the question of can the judiciary withstand scrutiny under its own state bar moral character standards with a particular focus on U.S. Supreme Court justices. More importantly, I did previously address topics regarding whether the judiciary can withstand scrutiny in prior videos, which I'm hopeful you watched. But here today, I'm going to explore from the perspective of just U.S. Supreme Court justices. Now, typically, one of the characteristics of determining whether an individual has good moral character, as indicated in the previous chapter on the judiciary taken as a whole, we focused on issues of whether a candidate for a law license is evasive or truthful, whether they engaged in false disclosure, incomplete disclosure, misleading disclosure, or whether they were open and displayed candor and truthfulness and honesty. Did they have a good attitude? Did they have a bad attitude? Did they conduct themselves with professionalism and civility, or were they uncivil? Now, the way this gets interesting with respect to today, as I explore the U.S. Supreme Court justices particularly, you're going to see that they tend to write opinions that are hypercritical of each other. They insult each other. They accuse each other of being dishonest, particularly the dissent more often than not. But quite often the majority in rebuttal does the same thing. They're nasty to each other. They're uncivil to each other. They call themselves liars, misleading, evasive. On occasion, they call their opposing justices as being perverse. So I'm going to read a series of opinions, not the whole opinions, just particular excerpts from selected opinions. Now, there's a PDF associated with this video, which you should be able to access. That PDF contains approximately 150 instances of U.S. Supreme Court justices completely being uncivil with each other, insulting each other, calling each other liars, calling each other evasive, deceptive, perverse, manipulative, all nasty things. So when it comes right down to it, they don't meet their own standard that they try to have the judiciary apply to the litigants and the applicants. And thus they cannot withstand scrutiny under their own standards. So I obviously can't read 150 of them here, but please look at the PDF. You'll see about 150 instances. I'm going to read as many as I can within a reasonable amount of time here right now. So in the case of Walker versus City of Birmingham, 1967 case, Justices Warren, Brennan, and Fortas wrote as follows. I do not believe that giving this court's seal of approval to such a gross misuse of the judicial process is likely to lead to greater respect for the law. Pretty nasty statement. Same case in the dissent writes as follows. And the court does so by letting loose a devastatingly destructive weapon. Different case, Street versus New York, 1969 case. Justice White, dissenting, wrote as follows. The court has spun an intricate technical web, but I fear it has ensnared itself in its own remorseless logic and arrived at a result having no support in the facts. In the case of Friedman versus Rogers, 1979 case, Justices Blackmun and Marshall, concurring in part and dissenting in part, wrote as follows. The ultimate irony of the court's analysis is that because of its broad sweep, it actually encourages deception. These are pretty nasty statements that the justices are writing to each other, and it's fair to say that if applicants at a bar interview or litigants in court or attorneys in court were to say these type of things to a judge, they could be looking at denial of their application for admission to the practice of law or contempt if said in open court. And yet U.S. Supreme Court justices put it right in writing quite often, and we're going to continue here. In Richmond Newspapers versus Virginia, 1980 case, Justice Rehnquist dissenting writes as follows. It is basically unhealthy to have so much authority concentrated in a small group of lawyers who have been appointed to the Supreme Court and enjoy virtual life tenure. In Metro Media Inc. versus City of San Diego, 1981 case, Justice Rehnquist writes as follows. It is a genuine misfortune to have the court's treatment of the subject be a virtual Tower of Babel, from which no definitive principles can be clearly drawn, and I regret even more keenly my contribution to this judicial clangor. I love that, judicial clangor. In the case of Reagan v. Time Inc., 1984 case, Justice Brennan, concurring in part and dissenting in part, writes as follows. Justice Stevens, largely ignoring the text of the statute, I believe he thereby carries the principle of construing statutes in order to save them from constitutional attack to the point of, quote, perverting the purpose. Perverting the purpose. Nasty statement to say to a fellow judge. Case of Walters v. National Association of Radiation Survivors, 1985 case. Justices Stevens, Brennan, and Marshall dissenting write as follows. The court does not appreciate the value of individual liberty. Unfortunately, the reason for the court's mistake today is all too obvious. It does not appreciate the values of individual liberty. Saying that to fellow U.S. Supreme Court justices is pretty harsh. Can't imagine if someone were arguing before the U.S. Supreme Court and said stuff like that, how well it would work out. Case of Texas v. Johnson, 1989. The court's role as the Justices Rehnquist, White, and O'Connor dissenting. The court's role as the final expositor of the Constitution is well established, but its role as a platonic guardian admonishing those responsible to public opinion as if they were truant school children has no similar place in our system of government. Case of County of Allegheny versus ACLU, 1989. Justices Blackmun, Brennan, Marshall, Stevens, and O'Connor in the lead opinion. Although Justice Kennedy repeatedly accuses the court of harboring a latent hostility or callous indifference toward religion, nothing could be further from the truth, and his accusations could be said to be as offensive as they are absurd. Justice Kennedy's accusations are shot from a weapon triggered by the following proposition. Although Justice Kennedy accuses the court of an Orwellian rewriting of history, perhaps it is Justice Kennedy himself who has slipped into a form of Orwellian newspeak. Case of Rutan versus Republican Party of Illinois, 1990. Justices Scalia, Rehnquist, and Kennedy dissenting. Thus, the new principle that the court today announces will be enforced by a corps of judges, the members of this court included, who overwhelmingly owe their office to its violation. Something must be wrong here, and I suggest it is the court. Case of Madsen versus Women's Health Center, Inc. Justices Scalia, Kennedy, and Thomas, concurring in part and dissenting in part. The judgment in today's cases has an appearance of moderation and Solomonic wisdom, upholding as it does some portions of the injunction while disallowing others. But that appearance is deceptive. You know, these like completely violate all the so-called good character traits of truthfulness, honesty, forthrightness, and instead they are all accusing each other of being evasive, misleading, deceptive, perverted. Case of Board of County Commissioners versus Umber, 1996, Justices Scalia and Thomas dissenting. What secret knowledge, one must wonder, is breathed into lawyers when they become justices of this court that enables them to discern that a practice which the text of the Constitution does not clearly prescribe and which our people have regarded as constitutional for 200 years is in fact unconstitutional. Same case, Justice Scalia and Thomas dissenting. This is a famous quote, and it was in the newspapers actually when it came out because it was incredible that Justices Scalia and Thomas actually wrote this. And here it is. The people should not be deceived. While the present court sits, a major undemocratic restructuring of our national institutions and mores is constantly in progress. The court must be living in another world. Day by day, case by case, it is busy designing a constitution for a country I do not recognize. Case of Orr v. Orr, 1979, Justices Rehnquist and Berger dissenting. Much as Caesar had his Brutus, Charles I his Cromwell, Congress and the states have this court to ensure that their legislative acts do not run afoul of the limitations imposed by the United States Constitution. But this court has neither a Brutus nor a Cromwell to impose a similar discipline upon it. Rose v. Mitchell, 1979, Justices Blackmun, Brennan, Marshall, White, and Stevens, lead opinion, but claims that the state judiciary itself has purposely violated the Equal Protection Clause are different. There is a need in such cases to ensure that the independent means of obtaining review by a federal court is available on a broader basis. Case of Harris v. McRae, 1980, Justice Blackmun dissenting. There is condescension in the court's holding. There truly is another world out there, the existence of which the court, I suspect, either chooses to ignore or fears to recognize, accusing fellow justices of just ignoring their duties. Bradwell v. State. This is actually a very old case. It's from 1872, and it involves the admission of women into the practice of law. And the quote is as follows from a concurring opinion, which is as follows. This is incredible. I'm sure female lawyers are going to love this. It's 1872 regarding the admission of women to the practice of law. And the concurring opinion writes as follows. This is incredible. The civil law, quote, this is how it goes. The civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of man and woman. Man is, or should be, woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. Here we go. The paramount destiny and mission of woman are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator. Incredible. Plyler v. Doe, 457 U.S. 202, 1982 case. Justice Berger dissenting in footnote 12 states as follows. The court's opinion is disingenuous. Jones v. Barnes, 1983 case, Justice Brennan dissenting, writes as follows. The court surprisingly announces that there is no constitutional right to an appeal. That statement, besides being unnecessary through its decision, is quite inarguably wrong. City of Cleburne versus Cleburne Living Center, Inc. Justices Marshall, Brennan, and Blackmun concurring in part and dissenting in part. No guidance is thereby given as to when the court's freewheeling and potentially dangerous rational basis standard is to be employed. The case of Kadermas versus Dickinson Public Schools. I'm not certain I'm pronouncing the first name correctly. It's Kadrmas. 1988 case, Justices Marshall and Brennan dissenting. The court's decision to the contrary demonstrates once again a callous indifference to the realities of life for the poor. The court fails. The court denies equal opportunity and discourages hope. City of Richmond versus J.A. Croissant Company, 1989 case, Justices Marshall, Brennan, and Blackmun dissenting. Right as follows. Such insulting judgments have no place in constitutional jurisprudence. And lastly, Price Waterhouse versus Hopkins, 1989 case, Justices Kennedy, Rehnquist, and Scalia dissenting right as follows. Today, the court manipulates existing and complex rules for employment discrimination. I said that was the last one. I got one more. Powers versus Ohio, Justices Scalia and Rehnquist dissenting right as follows. Today's opinion makes a mockery of that requirement. So when these justices and judges, whether in federal court, state court, or the U.S. Supreme Court, are telling people to be so professional, nice, and civil, just keep in mind what all these U.S. Supreme Court justices say about each other and to each other, and how they're evading their duty, being deceptive, manipulative, perverse, engaging in false disclosure. I hope you liked this presentation today. It is one of my more interesting ones. And we'll do the next video within the next few days or so, 3, 4, 5, something like that. And remember, love right, don't fight. Have a good one, everybody.